Okay, we will discuss question 5, 6, 7 of November 2023 evidence paper. All right. And I hope you have this evidence act with you as well as the question with you so that you can follow me through the this lecture session. Okay. As usual, I'll start reading the question for all of you to save your time. Okay. I will welcome a question from time to time, but I will prefer to answer at the end of this session, so that we can move on fast. Okay. We start by reading the question. Super Block Sendirian Berhad, Super Block, Subongkar Sendirian Berhad for breach of contract for the late delivery of a CNC machine for 3D milling and carving. So thereafter called as the machine. So Super Block here has claimed 200,000 for the loss incurred from the cancellation of the purchase order by its customer, which it would otherwise have made the machine arrive on time. So there's a default on part of Bonga here, and then it caused delay and damage and loss to the plaintiff. Okay. So the delay in the shipment of the machine to Superblock in Kuala Lumpur was beyond its control because of the various lockdown and restriction on movement imposed by government of China due to COVID-19 pandemic. Bongka has obtained certified true copies of the Malaysian Ministry of Foreign Affairs circulars on the COVID-19 pandemic in Malaysia. So at the trial, Bongka argued that the court should take judicial notice of the newspaper articles about COVID-19 pandemic in China and various lockdowns and restriction on movement in China. Bongka also argued that the court should presume the genuineness of the certified true copies of the Malaysian Ministry of Foreign Affairs circulars. Superblock intends to adduce photocopies of the purchase order and cancellation order by its customer in support of its claim for loss and damage. So, your first question here, hey, where is the highlight? Okay. Okay, your first question, they ask you to explain to Superblock's counsel whether the court can take judicial notice of the newspaper articles. Okay, I just want to remind to all of the students that attended this session or hear my this what we call lecture by YouTube, you must be very sharp with every words the examiner asks you. Okay, how do we do that? I will just explain by my sample of answer. Okay, first and foremost, this is when you zoom into a particular area of law here, this question invites you to discuss one area, judicial notice. Okay, judicial notice in Bahasa Malaysia, that means to say pengiktirafan, penghakiman. Okay, as you study the chapter of burden of proof here, okay, if you assert a certain facts in the court, the party that actually wants the court to believe that the fact is true bears the legal burden of proof. Okay, that means to say whatever I say, Ah Chong is wearing black color during the material time. I have to show to the court with various corroborative evidence to support this statement. Except there are two conditions where the parties is being dispensed with the need to prove. Okay, that is to say, we have two, okay, very important, judicial notice being one of it, that you do not need to prove to the court regarding to the assertion of the fact, if you can, let the court take judicial notice. And the second one is facts admitted by the parties. Fakta-fakta yang diperakui oleh plaintiff ataupun defendant ataupun the what we call the oketi lah, orang kena tuduh. You get what I mean? Judicial notice and also facts admitted by the parties. You need not to adduce any proof to discharge your legal burden. So judicial notice is something with the rationale behind it to save the time of the court. Okay, something that is very common that even your kong ama at your house will know the facts. The court will not need to go extra miles to take extra efforts to force the party that assert the fact to produce proof. For example, you said in your statement of claim, Kuala Lumpur is troubled, okay, with traffic problems. So this fact itself is commonly known by the public. Whatever who stay in Malaysia will know that Kuala Lumpur is having problems with traffic, isn't it? So you need not to show photograph in the court to say that, oh, you see, this is the photograph of the what we call Jalan Abdul Aziz or this Jalan Duta, for example. It's jammed all the way. You don't have to produce it, if the court take judicial notice. Okay, can understand so far? But then you must also balance the what we call the requirement of law here. Because the law clearly said if the prosecution bring the case against the what we call the accused, they have to prove to the court with whatever evidences beyond reasonable doubt, isn't it? If the plaintiff bring a case against a defendant, then the plaintiff will need to establish his case on balance of probabilities. The court cannot simply take judicial notice on every single matter, isn't it? So you have a complete list. You have a complete list in actually section 57. These are the lists that the court must, you see the word here, shall, isn't it? The court must take judicial notice over section 57, subrule 1 until this one, until O. Compulsory, the court must take notice, okay? Usually, these are the area that is non-arguable by the parties. Like, for example, the Public Act passed by Malaysia, Commonwealth country, UK, for example. These are the things that is without dispute of the parties, okay? But however, you must also realize that this list itself is non-exhaustive in nature. That means to say the judicial notice is not confined to the boundary of section 57. But the court should exercise test. This is a very objective test we call notoriety test. That means to say the fact itself must be so common, okay, so easily well appreciated by public without much contention or dispute. Tak payah cakap lagi lah, tak payah argue lagi tentang kebenaran fakta ini. Okay, this is the notoriety test. Okay, sufficiently notorious for the court to understand. It must be within common and general knowledge and accepted by public without qualification or contention. Okay, famous case here used to Johnson Tan Hang Seng, as well as one case, civil case, Pembangunan Mahamuni against Juru Urus Ladang Sediran Berhad. These are the tests behind the court. Okay, Very important, eh? Now we turn to how to answer this. How to answer the question asked. Okay, first and foremost, you need to, because this is a 12 marks question, So 12 mark question, you cannot just limit your arguments. When you are seeing things wider, in a wider perspective, you can pick up a lot of things. For example, now the contention is that the information is from where? It's from a piece of article from the newspaper that's suggesting there is COVID happen in China and there is a lockdown in China. Isn't so? So first thing first, is the newspaper piece of recognized evidence? Is it a hearsay? That's my question. Or do you need to, let's say, for example, a newspaper is probably from Sinchu, Delhi. Do you need to call the reporter that report the case to verify the content of this newspaper? Okay, this is the first question you need to ask yourself. Okay, whether it's a hearsay or not. So you argue a little bit on this by saying Section 81 of Evidence Act will have a presumption in law to say that the court shall presume the genuineness of document published in a local Malaysia newspaper. Okay? You get what I mean? So this is what is the exclude the newspaper from being taught by documentary hearsay rule. Very important, But however, this provision itself does not really justify the court to take judicial notice over the information provided by newspaper. Okay, so this is your second argument here. But you must discuss a little bit section 81, Okay, this one only help to establish anggapan bahawa the content of the newspaper is not a hearsay. Okay, very important, And subsequently, you go to the point. Okay, first thing first. First thing first, newspaper, does it reflect the truth all the time? This is a very challenging question. Usually, the court will take a position that the newspaper is being processed by a reporter who wrote the article, isn't it? The news reporter typically in their custom of practice, whoever that feed them the information, they will write. Their job is not to establish the truth of a matter, but rather to make a news, some information available to the public to establish whether they believe the news or not. That's why you have fake news, isn't it? So, as established in this case, Malayan banking against Yo Sun Tong, the court typically does not take judicial notice of facts mentioned in the newspaper because newspaper itself is not something like gazette, it's not something that published by government agency. It's not published by Kementerian Dalam Negeri, isn't it? Sometimes the newspaper may contain hearsay and unverified information. So, therefore, to accept newspaper as the source of information and also to ask the court to take judicial notice, in my opinion, is not safe. Okay, the court will only take judicial notice over something that is without dispute, without contention. Okay, this is my first argument regarding to the source of information. Okay, second, you must try to argue in your best efforts what are the content, apa kandungan dalam surat khabar yang you nak mahkamah mengambil iktirafan penghakiman. Apakah kandungan. So there are two things, The first is, of course, in regards to the COVID pandemic in China, isn't it? You see, if it happens in China, because you see the way that I formulate my answer, I already say no from the beginning. I don't want to contradict myself. When you frame an answer, do not have something that sometimes you think that should go to the left, and sometimes you want to go to the right. As a matter of fact, whenever you go to court, there's only one winning party and one losing party. That's it, isn't it? So you choose your side with a clear and precise direction. So I want to formulate the answer that I don't want to take judicial notice. So now I'm the judge and probably for the opposing counsel. I will frame my answer to deny the emission of judicial notice here. Okay, I will say that COVID pandemic in China is beyond the knowledge of general public in Malaysia. How do a public in Malaysia will know what happened at that material time? Lah? I mean, what happened in China? Okay, so this is not a common knowledge, and this is not even accessible by a general public of Malaysian. So a lot of contention, a lot of dispute may be raised over these facts. And apa nama? Second fact is about the lockdown. The lockdown clearly in your facts, you can see here. Okay, restrictions on movement imposed by government of China. This suggests to you what? This suggests to you, there is some rules and regulation thing. Okay? And generally, if it is not a Commonwealth country, this is China, isn't it? Not a Commonwealth country like Singapore, Australia, New Zealand, all that. Generally, the court should not be taking judicial notice of a foreign law. Okay? So this is a lockdown measure imposed by government of China. Therefore, it should be an expert opinion evidence under section 45. And you can use the case of the Lang Yong here. Okay, the Lang Yong case. If it is a foreign law, except the one published by Commonwealth and also UK, it is not inside the list. So you conclude as a whole because your source of information and also the contents are highly disputable, therefore cannot take judicial notice. Okay, so this is the answer for question 5A. Okay, and you must be able to recognize there is one section here, section 50, 57, sub rule 3. Okay, it reads in such a way, where is it? I think I put it here. Okay, if the court is called open by any person to take judicial notice of any fact, it may refuse to do so. Okay, so your authoritative, the court is being granted the discretion, to reject this newspaper punya call to take this judicial review. Okay, so you must be able to cite this at the end of your conclusion. So my position is very clear. I reject the acceptance of newspaper articles as judicial notice. Okay, and B, okay, advise Superblock's counsel whether there is any merit in Bongka's argument that the court should presume the genuineness of the certified true copies of Malaysian Ministry of Foreign Affairs circulars. Okay, again, read every single word as in detail. Okay, I'm sure you know by now what it mean by presumption. Okay, presumption is something that anggapan. The court will presume a thing, whether by law or by facts or mixed law or mixed fact about the existence of something. Okay, that means to draw some sort of inference. Lah. Okay, for you to go into the discussion of presumption, you cannot simply just, okay, the court can presume lah. This one's certified true copy. You presume this is real lah, something like that. No, it doesn't work that way. For you to invoke a presumption, take for example, the famous presumption is, I believe you know by now, the section 114 illustration G, the adverse inference. This is a very commonly tested area. For you to invoke presumption, adverse inference against the opposition opponent, take for example the prosecution, you must prove the basic fact that the prosecution's other evidence itu tahu. Tetapi we hope sengaja tak mau bagi kepada mahkamah. Okay, something like that. And then the evidence itself adalah sangat penting, material evidence, not a simply, very important punya, very unimportant evidence like collateral one. Okay, so these are the basic facts that you should prove to the court before you can invoke presumption. It works for all the presumption across the evidence law per se. Get what I mean? So you have to mengemukakan fakta-fakta asas terlebih dahulu. Jadi apakah fakta asas pada dokumen ini? So you can see it is a Malaysian Ministry of Foreign Affairs circulars. That's why I say every word means, Okay, now you know the circulars is from Kementerian, isn't it? So Kementerian documents automatically just focus your mind. This is not a private document. This is a government, public document. So you briefly discuss section 74. It qualifies to be a public document. Okay, very important. After that, once you establish this is from Ministry of Affairs, etc., you must talk about the second facts of this the whole, because the question clearly gives to you already certified true copies, isn't it? First is about public document. Second is about certified true copies. So where can you find the provision under Evidence Act to say this is certified true copy? Okay, two provision, section 76 and section 77. Roughly, it talk about the officers, usually the professional and also the UD 41, the one that category higher rank officer can sign certified true copy, sign, chop, and dated that document. So this is considered certified true copy. The meaning of section 76 and 77. Okay, after you have talked about this, then you move to the section 79. You cannot simply just jump into 79 itself, because 8-mark question, You must discuss one case here and also the criteria set out here. Okay, so section 79, that is actually the gist of your what we call your answer here. So section 79 actually compel, you see the word here, shall. Okay, shall presume the genuineness of certified true copies if they are duly certified by an authorized officer. Okay, that's why I said this one must be established first. This means bongkar certified true copies are presumed genuine unless evidence is presented to rebut this presumption. Okay, because presumption itself will cause the other party to discharge their burden. That means once you establish, okay, let's say lah, this is my documents. I am for Bongka. All I need to do is to ask the court to check, okay, this is something produced by Ministry of Foreign Affairs first. Second, you see the chop there, certified by, just now I say what? The kumpulan professional punya certified officer. Okay, these two criteria forward to the court with my documents. That means to say, the content of the document is no longer a documentary hearsay. I don't have to call the itu diplomat lah, the pegawai to come to the court to to verify the content, okay? Because it will be a genuine copy. Okay, so this is what it means. Okay, and the wording that you must be familiarized is that, you see, okay, provided the document is substantially in the form and purports to be executed in the manner directed by the law. Okay, that means to say the date must be there, the chop must be there, and also the name of the what we call the sign of the officer that authorized to do so must be there. Okay, this is provided under your sections 76 and 77. Okay, as an effect, you must also discuss what is the effect of these documents if it is presumed. Okay, as an effect, the said circulars cannot be denied from being admitted, even though the maker did not call, is not being called to testify in the court. Okay. The authenticity of the proof, that means to say, if let's say this anggapan, this presumption is being invoked, you cannot put no doubt lah, you will put lah in bahagian C, isn't it? But if the presumption is being raised, take for example that the basic facts are well established, nama, chop semua ada, so the court will not dispute the authenticity of the proof itself, of the documents itself. Okay, and the word shall here means that the court has no discretion. It must presume, okay, if the basic facts established. But having said so, okay, if let's say super block can actually challenge the presumption. Every presumption is not a what we call unchallengeable, You must I presume you know, isn't it? Think you know, so my thinking, my thought process here is not something that is so uko. It's not concrete one. Okay, so you have to challenge by producing facts. Okay, you get what I mean? So Superblock can challenge this presumption by raising, oh, look, you see, how you challenge the presumption is that you can challenge these signature by the so-called officer is a forged one because you do a background check. Oh, there's no such officer called Ali bin Mahmud in the Ministry of Foreign Affairs. This is one part. You challenge it. So this is rebuttable with your facts here. Okay. But come back to your question here. Okay. You must stand a concrete conclusion because the facts provided is not much. It does not say the form and also the manner of this certified true copy is well observed or not. But somehow or other, Bongka's argument here got merit. Because whatever the Bongka spouses say, the court should presume the genuineness of certified true copies memang got merit. Okay? So this is your conclusion. But to make a better one, you can actually say that because you need to advise super blocks counsel, isn't it? Uh, you have to advise him to provide compelling evidence to the contrary. Okay, that means to say this is not even a certified true copy, this is not public document. But frankly speaking, a bit hard lah. Okay, can understand so far? So question C, advise Superblock's counsel on the admissibility of photocopies of purchase order and cancellation order by Superblock's customer. First thing first, it is relevant, lah. Okay, relevant. But this is not the primary discussion of this what we call this question, but rather they want you to talk about whether secondary documentary evidence. Okay, that means the photostat documents can be actually admitted or not. Okay, this is section 61. Sorry. Okay, so section 61 actually said that kandungan document, isi kandungan document can actually be proved by two ways. That is primary evidence or secondary evidence. Okay, primary evidence means the original copy of the documents should be produced before, the judge, in order for you to show that, see, this is the original copy with the real signature of the parties, and this is the content of it. This is one. But however, Section 63 also said that photocopies can be considered as secondary evidence if they are accurate image. They could reflect the content of the original one. Okay, so, but having said so, you cannot simply just come to the court and just produce secondary evidence without proper criteria. Okay, so super blocks must demonstrate where is the original documents? Mana pergi? Mana hilang? You must establish the facts and also merits. You don't have the original document. I cannot get the documents without a lot of efforts, delay, or expenses. Or you must prove to the court, okay, because of one, kebakaran berlaku kat office, lepas tu semua dokumen sudah terbakar. Something like that. You need to prove to the court why you cannot locate the original document. Okay, very important. If not, you cannot simply admit secondary evidence. This is how. Okay, because 5 marks question don't talk too much. Conclude by saying you can admit the section 63 sub rule 1. Okay, don't go specific because the fact is very short. So you do not know whether it's lost or is with the other party, something like that. You don't need to produce. And the content of the document could be admitted under section 63 sub rule 2. Okay, this one also you don't need to discuss about the detail of the sub provision. Okay, but you have to discuss these two lah, at least. Okay, for you to qualify to score a higher marks. Okay, can understand? Photostat can admit, but need to prove to the court why original tak ada. Okay. Okay, we go to the next question, question 6. In a WhatsApp apartment residence chat group, Daria referred to John as a neat compo for just suggesting that residents be fined 1,000 ringgit if they park their vehicles indiscriminately on the apartment grounds. John was furious and messaged Daria to apologize in the chat group. Daria refused. In anger, John stormed into Darius' apartment and hit him. Daria proceeded to lodge a police report. John is immediately called his neighbor, a lawyer. John explained the assault incident and asked Lauya if he could help. After listening to the whole conversation, Lauya explained to John that he was not a criminal lawyer, that he will refer the matter to his friend, Mr. Gu Wang. A few days after the assault incident, John confessed to his wife, Amber, that he felt good after hitting Daryl. John had this conversation during the time John and Amber were separated. Feeling remorseful, John visited Father Simon, his church priest, and admitted the assault on Daryl. During one of the marriage counseling sessions with Dr. Debbie, a psychologist, so Dr. Debbie, in his view, felt that John has anger management issues. Okay. 2 months later, John was charged with assaulting Daryl. The prosecution intends to call Lauya, Amber, Father Simon, and Dr. Debbie as the prosecution witness. Okay. Here, you are being given a lot of marks, 25 marks to discuss on the competency and also compellability of the listed prosecution witness as above. Okay. By now, you should understand there is a distinction between competency and also compatibility. Okay, compatibility. Okay, so tongue twisting, this word. Okay, competency means every single person, so long they can understand what are the questions put forward to them when they are inside the witness box of a court. Okay, and they can answer with a rational answer. Okay, they can give a rational answer towards the question asked. These people are deemed to be competent witness, because why you need to label a person as competent witness is that some some witness, for example, they have a tender year, 5 years old, 6 years old, for example, they are not able to differentiate the truth and imagination or sometimes fantasy. How did the court wanted to give judicial appreciation towards the evidence given by them? Okay, some people, some witness call, they have unsoundness of mind. They're crazy lah, in other words. So how did the court can be convinced if the witness is not competent enough? So this is one way. You have to discuss like essay, competency of the witness, etc. Okay, and then if you satisfy the competency test by right, every witness, if they are being asked a question, because they are on oath, on sworn evidence, isn't it? Sumpah, they angkat sumpah. You are required to produce the oral statement as to the question asked. That means to say every single question, you cannot just like that. I don't want to answer. I don't want to answer. No comment. No comment. You must realize the court is a place where truth of a matter is very important. So every witness, when they are being called to the court, they must be cooperative. They cannot say no comment, isn't it? Okay, so they would be, by law, compelled to answer every single question. Okay, but this is subjected to privilege. The privilege is on the issue of compellability. Okay, compellability is something to do whether the witness shall be forced to give any evidence or not. Okay, so beginning from section 121 until 131 or 132. Okay, you have your privilege section. Okay, that is, 132. These are the privilege, whereby if it is caught under the so-called privilege section, for example, if you are judge, you are magistrate, you are not required, you have those what we call immunity. acting as a presiding judge. You are not required to answer any question as to the conduct by you during the trial procedure. As well as if, let's say, the communication, let's say, husband got caught for some crime, whatever the information the husband told to the wife during the marital process, like the husband confessed to the wife saying that, okay, I did hit John lah, I did hit Daryl. This is amount to confession, but due to the marriage and the rationale behind that is because Malaysia need to keep the harmonization of the family institution, isn't it? This is the nucleus of our society. If husband and wife are not getting along well, they cannot hold each other's secret. You better don't be man and woman. You better separate, isn't it? So this is the rationale behind that, behind this section 1 to 2 lah. Okay, and section 1 to 6 extend to legal field. For example, a criminals come to me. Yeah, he admitted in front of me. I did hit Daryl. John lah. John is coming to me. I cannot go and tell or testify in the court. Look, John that day told me from his mouth that he did hit Daryl with his fist, like that. So this is how to upkeep the integrity, how to protect the information between the uh, client and solicitor. This becomes an issue. So this is under your section 1 to 6 up to 1 to 9 lah. Okay, so this is how you want to argue. You argue a little bit because it looks more like an essay question. So you must but you cannot discuss too general. You have to go back to the witness called by the prosecution. So we will in turn examine the position of one each witness here. Okay. First is Lao Ya. The question divided into two. So you have to talk about competency and also compellability. Okay, competency definitely is not crazy, isn't it? You can understand question asked, he can provide rational answer. Therefore, he shall be deemed to be a competent witness under section 118. And regarding the issue whether Lao Ya shall be compelled, shall be forced to disclose any communication or not, you must relate to the factual scenario given in the question. You see, the tricky part is that Lao Ya himself is not a criminal lawyer. He recommend to one person called Wu Wang, isn't it? So is there a client-solicitor relationship? The law say yes. The case law say yes. Okay. Even though there is no official appointment, there is no engagement after the communication, but whatever your information that you have received, okay, he's not acting as neighbor. The tricky part you must also discuss lah, neighbor. But he's listening to John's explanation in the capacity as a lawyer. Otherwise, I don't think John will go and find Lao Ya, isn't it, to talk about the incident. Malu, isn't it? So, when you listen to something with your professionalism, this automatically form the nexus, the relationship of solicitor and client, and it shall be existed, even though the relationship ends or it did not materialize in remuneration form. That means you did not get money lah. It also exists. Okay. Having discussed it is not yet enough. You must know there are actually two exceptions. You must briefly discuss. The two exceptions, for example, when the said communication is in furtherance of illegal purpose or there's some committance of crime or fraud, okay, in the exception limb under section 126, it is not fulfilled in the facts given. So unless John explicitly waive this privilege. Lauya cannot be compelled to testify about what John told him. Okay, so this is the full answer. You can refer to Dato Anthony C here. Okay, this one case is enough. Highlight your law. One more reminder is that you don't go and talk so much about the case law, but focus on the main statute, the main section. Okay. Second is about the wife. Again, competency. She's definitely competent, isn't it? Okay. And secondly, you talk about compatibility issue. Compatibility, because this is a marital communication. You see or not, the facts suggest they have been separated. But separated, does it mean divorce? To me, separated is not divorce because the legal term is not divorce, Okay, they are just berasingan. So I will put my way to suggest that the fact uh, they are separated, but they are still married, legally married. So whatever the communication that happened, John feel good after hitting their rear, they are still part of the marital communication. So it did not qualify any exception. Okay, under section 122 as well. You must elaborate also. If what are the exception section 122? If let's say this is a divorce case, divorce case, whatever you said to the wife probably can be used against you. Okay, this is how. Usually divorce lah. Or there is a domestic violence case. Whatever you told to the wife is no longer important because their relationship broke down. You understand, isn't it? What I'm trying to say. Section 122, I already said, I think multiple times, is to preserve the harmony for family. If the relationship is already gone sour, for example, domestic violence, and they are against each other in a petition of divorce. So this one, section 122 is no longer important. Okay, so this is how you memorize the section. You know a step behind why Parliament want this section to be there. There must be a reason, isn't it? Okay, so you conclude unless John consents to waive this privilege, Amber cannot be compelled to testify about this communication. You can use the case of Gos bin Haji Kadir Mustan. Very famous case. Okay. Third, Father Simon, priest. Okay. Competency, I think very much less argument. All of them seems to be competent witness to me. The issue of compatibility. Now the question is actually ask you to discuss whether Malaysia law has got a privilege in regards to religious confessions. Okay, religious confessions are in some Roman Catholic country, they do provide this religious confessions thingy so that their church, usually church lah, okay, can have their social status, whatever confession you made to the priest, the priest cannot come to the court and testify against you. Like you watch the US movie, psychopathic murderer used to go to the small room inside the church and give whatever information as regards to his killing, okay, to the priest. The priest cannot give, But in Malaysia and also Commonwealth country, from my little research here, are actually not protected. Okay, not protected. We do not have common law that safeguard the religious confession. Okay, so Simon here shall be compelled to give evidence in the court. Okay. So this is how. And Dr. Debbie, again, he's a competent witness. And in regards to whether he can be forced to give evidence, is that you must realize what is his position. Why Debbie go to the court? Okay, for example, Simon here is to give evidence which is relevant, under section 21. This is a confession, and also section 70 subrule 2. Okay, confession, very powerful type of evidence. So this is relevancy part. And if it is regarding to Dr. Debbie, why he want to give evidence? That is to give his opinion, isn't it? You remember the text. Debbie, a psychologist, in his view. That means to say, he is here, Debbie is here. There are two types of witness. One is factual witness, okay, saksi berkenaan fakta. And second is opinion witness. Okay, saksi memberi keterangan tentang pendapat. I think I, from my medical knowledge, I think this doctor is negligent. From my medical knowledge, I think the cause of death of the disease is due to stabbing wound over his neck. This one is opinion. So Debbie here is giving his view. So he's a opinion witness. Okay. So first you argue. Generally, the Proviso Inside Evidence Act did not actually qualify or apply to psychologists. But somehow we have medical ethics. That is wait, somebody's, I need to mute them. Okay. Somehow or other, we have medical ethics which respects the patient's autonomy and also confidentiality, may offer some protection over the privilege issue. But then the principle is persuasive only, and it is not binding to the court. This is your argument. Somehow or other, again, you must understand the role of Dr. Debbie. Okay, if we can draw an analogy from the case of Dr. Pritam Singh here, Dr. Pritam Singh, generally, if let's say an evidence is provided by an expert, in this particular case, probably is to prove the mens res, of the crime. Okay, like this John is somehow or other cannot control his anger, etc. Okay, so you need not to disclose to the other parties one. So generally, medical report and opinion of the witness, if it is for the purpose, the dominant purpose the dominant purpose is for the litigation provided, it is provided under section 127 evidence. Okay, you cannot say 126 because psychologists themselves is not an advocate, but somehow you can fit into the wording of section 127. Psychologist is called by whom? It's called by prosecution, isn't it? DPP. So they are advocate. So this Dr. Debbie probably is being engaged, employed by prosecution. They are servant of advocates. So therefore, it is likely that Dr. Debbie would be privileged from giving his evidence. Okay? So this is how lah. And we go to the last question. Okay, time passed very fast. Ahmad and Bajak are charged under Firearms Increased Penalties Act 1971 for robbing a bank in Klang with firearms and fatally shooting the bank security guard. The DPP's evidence against them is as follows. Okay, first, we examine one by one and then we discuss easy because we are here to advise DPP on the law of evidence that can be applied to implicate Tama and Bajak with crimes that they have been charged with. Again, 25 marks. Okay. When they give you this sort of question, they invite you to discuss about the relevancy chapter. This sort of question, please do lah, because divided marks like that, easy to score, Okay. Okay, first thing first, you must come to know by now, Section 5 of your Evidence Act, not every single piece of evidence shall be allowed to be admitted to the court. Only two things can be admitted to the court. That are facts in issue and also relevant facts. Okay, only two things can be admitted by court. And this is a matter of question of law. The court will have absolute discretion to reject if the fact is not relevant. Tak ada kaitan lah. Okay, tak ada kaitan dengan case. So, apakah kaitan dalam case ini? You must be able to identify this is a PP against Lama and Bajak case. Sorry for the typo. And this one likely to be Section 4 of FIPA. Okay. In order for you to understand this question in a bit better one, okay, so Section 4 actually provides what is it? Penalty for exhibiting firearm. See or not? Keywords here, firearm in the commission of a scheduled offense. Scheduled offense here probably is the robbery lah, or killing, because the security guard died, isn't it? Okay. So firearm and also robbery are relevant facts in issue. Okay, get the meaning, and the rest are not very important, punishment with death or all that. Okay, not very important. Okay, so we go to A. Okay, A asks you to talk about DSP Karma's evidence that 4 days after the robbery, Karma was arrested in Taipei Perak where 100,000 cash. Okay, first thing, 100,000 cash, Tamak's mobile phone and also SIM card were seized from Tamak. DSP Karma also gave evidence that Tamak was unemployed. Okay. So you have to, because 25 marks usually, you must read beyond the lines. Cannot just simply gas out one and there, then you lose a lot of marks. Okay, first, okay, relevancy. 100,000 ringgit. Is it relevant? I will say yes. Okay. Why is that so? You justify your answer. I will put my answer, section 7, and this amount of money is likely to be the proceeds from the robbery. It means you rob the bank, you get the money. This is how relevancy section is being used. And you can actually bring the 100,000 ringgit to be tendered as one of the real evidence as exhibit TW1, for example, in the court. Okay, this is under section 60 sub-rule 3. Okay, and in regards to mobile phone and SIM card, at this moment of time, there's no much issue about the SIM card and also the mobile phone, because you must understand, the charge is section 4 FIPA, isn't it? It's about the robbery and also the possession of firearms there. So what is it has to do with the SIM card and also mobile phone? So at this moment of time, I don't think this is relevant. Okay. And one more facts that you can read from sub question A is that DSP Karma said Tamak tak ada kerja. So it helps to establish this motive. Why he robbed the bank? Because tak ada duit. Okay. And supporting the inference, the motive. Okay. He obtained the money illegally also. because he doesn't work, or this number one motive, he robbed the bank because he did not work. And second fact is that 100,000 belong to him. How can an unemployed person suddenly have 100,000, so much of money? Cannot be. Okay, so this is provided under section 8. Okay, Buta Singh case you can use. And B, we move to Inspectors Raja's evidence that after his arrest, see, keywords are there. After his arrest, Ahmad led Inspector Raja to Hana's, Ahmad's girlfriend, flat in Georgetown, Penang. There, the police found cash amounting to 300,000 ringgit. And then Ahmad then led Inspector Raja to his parents' house in Kulim Kedah, where a further sum of 200,000 ringgit was retrieved. I know many of you will get very excited when you read this sort of question. Oh, I know this is section 27. But like I said, be a very thorough and very tedious type of person to scrutinize the evidence. Okay, piece by piece, you dissect it and then you present to the examiners. This will help you. Actually, this is what we do in the court also. First information is what? The fact that Ahmad provide information. Okay, it's not the act itself, is the statement given by Ahmad that lead to the discovery of the money. This one is actually under section 27. Okay, it show that Tamas got no lash lah. Dia tahu duit tu sembunyi kat mana. Okay, so section 27 okay, this is also one privilege under section 13 if you know, you must fulfill some of the criteria, not easy like that. So the keyword here, the statement, usually this is the true lah because it's given here already after his arrest, isn't it? Okay, after his arrest and also within the custody of the police, and who gave the information? It must be coming from the mouth of Tama. Okay, and this one, again, go back to the point. It's not the money that is admissible yet, We talk about informasi. Okay, informasi. Rakaman percakapan lah. Okay, is admissible. And the money must be discovered after the information given. It's not like the police know where the money is hidden and then click Tamas to produce this information so that they can emit section 113 rakaman percakapan under section 27. You get what I mean? It must be a form of discovery as compared to recovery. This is what I'm trying to say lah. You can use the case of Muhammad Desa bin Hashim against PP. Okay, so first part, you briefly discuss section 27. And you must also remember, how about the proceed? Again, it could be tender as real evidence in the court. Okay, and furthermore, you cannot just stop there. What is the connections of the Hana's flat, the girlfriend punya, and also the parents punya rumah? It show planning already. It's a premeditated move. So this is under section 8. Okay, and the relationships between the parents and also Hana can actually pinpoint. No one else except this Mark is hiding the money, because the defense counsel can simply argue, ini bukan duit Katie, ini bukan duit saya punya, something like that. But how do you deny that if the relationship of the parents so close to you? You close one eyes also is belong to Tama, isn't it? So you must also use section 9 to establish this sort of relationship, so that the identity of Tama, who has hide the money, cannot be overturned by the opposing party. Okay. C, ASP CDEX evidence that he arrested Bajak 8 days after the robbery at a fruit orchard in Ganga Police and seized Bajak's phone and SIM card, as well as cash amounting to 150,000 ringgit and 10 million Thai baht. SV CDEC also gave evidence that Bajak was an odd job worker and incapable of having such amount of money. Okay, first thing first, again, there is a redundancy and also repetitive usage of section. I will say that the money is a consequence of the robbery under section 27, section 7. Okay, but still, I dispute lah. Mobile phone and SIM card will largely depends on what kind of evidence obtained from it. If this is none, cannot be admitted. And Bajak was odd job workers support the inference why he commit the robbery. Okay, so this is under section 8. But however, I have one issue with ASP Civic's comment that Bajak was incapable of having such amount of money legally. Okay, I think for you to jump into a opinion, I think he wouldn't have this sort of money. This is not your job. This is a form of opinion. And generally, the court is of the view that if you are a factual witness, you are the one arresting officer, isn't it? You cannot give comment that, ayah, Bajak ni tak boleh apa? Tak boleh mempunyai wang yang sebanyak gitu. You cannot say like that. You can say that he's an odd job from your investigation, yes, but you cannot extend your statement to suggest that, oh, Bajak ni miskin lah. Dia takkan apa get the money legally, okay, without going to the extent to comment by your own thinking. Okay, so I think the comment of incapable having such amount, okay, is a form of evidence, and this is not relevant. Okay. And D, the evidence of DSP Samso, a senior analyst with the police cybercrime division in the forensic department, that he had examined Tama and Bajak's mobile phones and SIM cards. He found 180 calls and 70 SMS messages were made between Tama and Bajak a few days before the robbery, include messages on their planned hist. Okay. So relevancy, the cybercrime analysis which had shown 180 and also calls and also 70 SMS, okay, is actually suggesting preparation and planning. So under section 8, you can use Pamanaban case. The said messages could also, you see or not, this is PP against Ahmad and Bajak. You can show they are planning on one conspiracy. You get me? They want to have a common design or common intention to do a robbery job lah. Okay, so this is, again, you can use under section 10 of Evidence Act. So don't just limit your answer into just nama kata just relevancy chapter. You can use multiple version based on your interpretation on a particular facts. Okay, and you must stretch your answer a little bit since forensic expert analyst, isn't it? It's coming, isn't it? Okay, this is a form of expert opinion. You must remember whatever section from section 5 to section 55, it is grouped under relevancy chapter inside your Evidence Act. So section 45, yes, it is an expert opinion with evidence, but it is still a form of relevant evidence that shall be admitted by court. Okay, so DSP Samsu shall be required to explain to the court how the decryption happens, how he hacked into the phone, how the message is being produced. Okay, this is under section 45, comprehensive answer. Okay, and next, Shasha evidence that Tama had a few days before the robbery asked her to procure a gun and some bullets, which she did and gave to Tama. She handed the police bullets, which were the type she had given to Tama. Okay, see, so again, it shows occasion. Tama got the gun and bullets. This one, Trinity, because Shasha gave the gun after the purchase to Tamak. Okay, this one thing. And again, don't limit your discussion. It show planning already. Tamak bought gun. So this is very relevant under section 4 FIPA lah. Okay, it show occasion, preparation, and the means to commit the crime. This is the first fact that you can get from this statement. And second thing, she hand over the police bullets, which were the type she had given to Tama. This is what she's trying to help the police to identify lah. You tengok bullet ini yang saya bekal kepada polis sama seperti apa yang digunakan oleh Tama dalam robbery tersebut. So matching lah, the identity is there lah. Okay, so to introduce, it is the same bullet that we are talking about. So the chain of evidence here will not be broken. So this is how you discuss. And F, F. Ameng's evidence that Tama asked for help to bring Bajak to Thailand the day after the robbery without going through immigration. So this is highly suggesting of conduct after the crime. That means to say you did something wrong, you don't want to go, you want to flee lah, you want to flee to overseas without proper channel. Okay, so this one is suggesting of the guilt lah. Okay, and you commit something wrong in Malaysia already. Section 8. And last, the evidence of the pathologist, Dr. Azman, who examined the security guard's body and found 2 gunshots wound his body. He gave evidence that the bullets found on the security guard's body matched the bullets given by Shasha to the police. Okay, first thing first, if let's say Dr. Azman is giving evidence, he will be deemed to be expert. Again, expert. Okay, so he need to support his ground. This is what we call no argument. And second part is that the bullet thing is the same provided by Shasha. Is again, you can use section 9 to introduce the facts. Okay, that means to say the whole thing here will form a very nicely draft circumstantial evidence to support your case. Okay, to support prosecution case against both Tamak and Bajak. Okay, so this is how you try to answer. Okay, if you want to conclude also can. After getting A to G, because it looks like a essay question, you can conclude lah, the chain is not broken. You can even say a little bit about the irresistible conclusion test. You see, there's no alternative explanation as to the crimes committed by Ma and Baja, looking at all the evidence, etc. If you want to do so, okay. And okay, I hope you are still listening. That will be all